Good afternoon, everyone. Again, for those of you who are just joining us, I see two familiar faces, so you know the procedure, 20 minutes per side. Let me know when you approach whether you would like to reserve rebuttal time. Madam Clerk, you may call the next case.
Yes, Your Honor. State of Tennessee versus Sedrick, Darnell, Cummings.
Good afternoon, Your Honors. Drew Justice for the defendant appellant, Sedrick Cummings. I'll reserve 5 minutes.
Mr. Justice, can I just take a moment, just a moment? Can we get that door, Madam Clerk, closed? Is that possible? Usually we have a deputy seated right there, and I apologize. Thank you, Mr. Ball, for getting that for us. There he is. We probably started a minute early, Mr. Trooper. We apologize.
I'm going to try to cover both my issues here today to the extent that I can. The first issue...
Do you want rebuttal time?
I'll reserve 5 minutes.
Okay.
The first issue is that the evidence was insufficient to convict Mr. Cummings of this crime. And to start, I've got to say I've been a little bit confused at different points in the case as to what the crime even is. At trial, I thought the crime was that he assaulted her by telling her that he was not going to shoot her with the gun he didn't have, whereas on appeal, the state seems to admit that that first theory doesn't work, and now their main argument is that he assaulted her just basically because he's a crazy guy, and anytime he gets angry, he may just start swinging just without warning.
Well, let's back up. I understand your argument, basically that they relied on, I guess, the assaultive behavior for the other count, which was dismissed, correct?
They said that they were relying on the assaultive behavior under the 404, and I was going to cover that later, but they said they were relying on that under 404 for this count, I believe.
Okay, then that's my question. Can they not rely on that as well, even though they said in their argument at trial they separated the two? Does that make sense? What my question is whether they can also rely on it at this point, because it was presented to the jury overall.
Some evidence of him being a violent person in the past, not here, but in the past, was introduced.
No, I'm talking about him grabbing her neck.
Oh, okay.
I'm talking about the offensive touching facts.
The offensive touching, I would say, in theory, that could be evidence. I mean, it would sort of depend on the specifics, but at least I would allow that in some scenarios, if you're grabbing someone, pulling them over across the room, maybe being kind of verbally hostile, that might be sufficient for them to think that you're about to hurt them, and then that could be an assault. I'm not saying that is necessarily sufficient here, because she didn't really describe it as being violent, in my view. But whether she did or didn't, ultimately the main reason it's not sufficient here for an assault is just because she didn't describe that as putting her in fear. And she was specifically asked by the DA how it did make her feel, and she just said it offended her. It said it made her feel small, belittled, etc. And so she didn't say, I thought he was about to push my head down all the way onto the counter and bump my head, or I thought he was going to jerk me in some other way and hurt me.
I thought there was some testimony that at some point she thought, I know it was in the future, but she said something to the effect of, I knew it was going to happen. He was going to kill me or something.
Like it's just a matter of time before I was either going to be dead or hurt badly or something along those lines.
She said she knew.
Didn't she say that? Did she, or did she not testify to that?
She said she knew that one day he was going to kill her, whether it be that day, and then she stopped, so implying, or some other day.
So why isn't that enough?
Because that's not, because that's not coupled with what Your Honor just talked about with the grabbing her by the neck. So she didn't say she felt that way.
So we have to separate it?
Well, I think you do, because by the point she said, like, she was worried about getting killed someday, the moment had already passed where he had already shown her the child support papers and said, look at these, how would that make you feel, that kind of thing. So there wasn't any further imminent, there wasn't any possible imminent threat by that point, by the point when she said she was worried about getting killed someday. Further, and this works both for the gun theory or just any other theory. I mean, when she's specifically testifying that she thinks something's going to happen someday, you know, maybe today, maybe some other day, that's pretty much an admission right there that any kind of fear you're feeling is not of an imminent injury. It's of something that might happen 5 years from now if I don't break up with this guy or whatever.
But couldn't a jury, I mean, this is, you're arguing sufficiency. Couldn't they infer from that what she was talking about was in that moment?
I mean, the problem is just that when she said that she felt like he was going to do something to her either that day or some other day, she wasn't being threatened at that point. Like, there wasn't any more talk of the gun that he didn't have and not shooting her. There wasn't any grabbing of her neck and making her look down at something. There wasn't anything. They were just having a discussion. And so for her to, at that point, say, like, you know, I feel like this is a violent guy. He might hurt me if I don't leave. Okay, well, let's assume she's telling the truth and that's a legitimate feeling on her part. That's still not an assault. That's just a wise thing for her to fear. Like, this is a violent person. He's angry. I should get away from him before he assaults me.
It wasn't like they were just sitting there having a calm discussion about the child support papers. You're not trying to lead or mislead us down that path, are you?
No, I'm not trying to say it. I mean, he said he wasn't yelling. He said he raised his voice some, but no, I'm not trying to say it was a calm discussion. It was obviously an angry discussion on one or both of their parts. But an angry discussion and an assault are two different things. For an assault, you can't just, you know, say, well, I'm friends with or boyfriends with or whatever, girlfriends with this violent guy, and I know he's dangerous, so anytime he speaks ill toward me, he's assaulting me because I reasonably fear he might start swinging at any point. You know, he supposedly broke my tooth 2 years before, so who knows if he might do it again. For it to be an assault, I would say he'd have to either, like, you know, get close to her and say, I'm about to hurt you, or do something physically that would make it look like he's about to hurt her. Or, you know, obviously if you're going all the way and just swing in and, you know, even if you stop before you reach their face, that could still be an assault by fear. But if you're just speaking towards someone in an angry manner, that means you need to get control of your, you know, your heart, your temper, and not assault someone. It doesn't mean you've already assaulted them just by being angry. And I did cite, you know, a few different cases on this. There was one from Texas, I believe it was State versus Hill, or no, it was Devine versus State, one of those two. It was where someone was in handcuffs and he was threatening a deputy who had arrested him, threatening to kill the deputy, and the Texas Court of Criminal Appeals said, well, it's not an assault because, you know, in order for him to assault you, you'd have to get out of the handcuffs and maybe book out of jail, bond out of jail hours later, whatever, and by that point it's not imminent anymore.
But that's really different from this situation.
Well,
wouldn't you agree? I mean, nobody was cuffed, nobody was restrained. He was angry. She said she was scared, you know, about what he was going to do then or at some point.
Right. Doesn't that go to his ability to do it?
I mean, that case was, I guess, a little bit more relevant on the question of whether he's going to shoot her with the gun that's supposedly down the hall in the bathroom or whatever. But I would agree that, in theory, he could have assaulted her and he could have physically hurt her, I would think, unless she's really good at defending herself and maybe she can fight him off. But that doesn't change the fact that he didn't do it. And unlike the inmate who's handcuffed, Mr. Cummings wasn't, no one's claiming that he was threatening verbally to hurt her. And so
but he doesn't have to do it, it's just placing her in reasonable fear, right?
Well, I mean, my position is that just because your hands are registered as lethal weapons or whatever, that doesn't make you guilty of assault anytime you get into a heated argument with someone. And so the state's state's argument is that just because he's angry and he might assault her, therefore he's already assaulted her, and I don't think that's correct, because one, it's not, even if someone's dangerous, it's not reasonable to fear imminent bodily injury from them before they've made any objective showing.
Isn't that a question for the jury to decide whether they felt she reasonably feared imminent bodily injury?
I would say it's
based
not,
on all of the facts that came out to the jury?
I would say it's not a question for the jury because it's objectively unreasonable and there's no way a rational jury could find any imminent threat here. If he's just yelling at her, that's not, no rational jury could conclude that that's an imminent threat of injury.
So you, again, I'm listening closely to your argument to try to understand it in context of the brief that you filed. And again, you're going back and isolating the facts to the statement that the defendant made. You're lucky I'm not blowing your effing brains out. How could you do this to me? And as I asked at the top of the argument, I was asking you, isn't there more that the jury considered in this case than the mere language coming out of the defendant's mouth? And you're kind of doing both. You're kind of saying, yeah, it's a little bit, but then you go back and say, no, it's just the statement.
Well, what I'm saying is that if she had squarely testified that I was afraid he was about to hurt me in conjunction with grabbing me and making me look at the child support papers, then that might have been sufficient.
Okay.
But she didn't say that, and she basically said the opposite. She said, I just felt offended, in so many words. And so therefore, I would say that, you know, in some other world might have been enough for an assault, but here it wasn't because she didn't claim any imminent fear from that.
Okay.
And then the point when she did get into being afraid, it's after he's, you know, let her get up from the counter, and then they're arguing some more, and then she decides to leave. And the reason she decided to leave was because she was afraid he might do something to her that day or some other day. And so that's why I'm separating them. I view it as, you know, 2 or 3 different things. There's the comment about the gun, and there's grabbing her and making her look at the child support papers, and then they're arguing some more, and she decides to leave. Then I wanted to briefly touch on this 404 issue. The judge, I would submit there are a number of reasons why it was error to admit this evidence. The state has talked about the fact that the record's a little confusing about whether he only admitted the item about the tooth, or whether he also said, and you can also just ask her, does he beat you up in general, or is this a pattern? The comment about that can be read one of 2 ways. I don't know exactly what the judge meant by that. I missed that when I was first in the trial and looking at the record. But assuming he was saying you can get into other items that I haven't found by clear and convincing evidence to be true, then that would make the error even more egregious, and it would also lower the or raise or whatever the standard to de novo review, which would make it easier for me to, in theory, get a reversal on. But even if he just admitted the tooth incident, I would say that it was error because, one, it's an incident from 2 years before. It's a single incident, so it's hard to see how you can get much relevance out of that in any kind.
Can I ask you to speak to the line of cases that we have out of this court consistently holding that we admit this type of evidence to establish, I guess, the intent. When you have a familial relationship, especially in domestic situations, this evidence is admitted time and time and time again. And I didn't see that you actually addressed that in your brief.
I touched on it real briefly, and I basically said that was what the judge was basically relying on, and I said that he was in error because in State versus Gilley, the Tennessee Supreme Court specifically said that these types of incidents are not per se admissible just because there's a relationship between the parties.
Yeah, per se. I mean, nothing's per se.
Well, and what I'm saying is that the judge seemed to have treated it as a per se rule where it's just any time there's a relationship, it should be admitted. In any event, due to the fact it was 2 years old, the fact it was a one-time thing, that the judge found to be clear and convincing, coupled with the fact that Mr. Cummings was not charged with hurting this lady 2 years later or with even trying to hurt her or intending to hurt her. He was charged with scaring her by talking about a gun and whatever else. And so it's hard to see how any intent could have flowed from one point to the other 2 years later. Moreover, the court cases, State versus Benjamin Gunn, talked about the fact that the state's not supposed to be able to use a prior bad act just to prove its mens rea. And in State versus Tolliver, the Supreme Court talked about how if the mens rea is supposed to be knowing, then intent really has no bearing on the case anyway, and so you definitely shouldn't be allowed to use a 404 act to prove intent. And that's what the state did here. And then in terms of showing that the prior act made it reasonable to fear Cummings, again, that's just sort of putting the cart before the horse, because it doesn't really matter whether it's relevant to fear him. What matters is whether it's relevant to fear him while he's in the act of threatening you, and there was no foundation that he was ever doing that. And so, in any event, I'm about out of time, but I'll come back for rebuttal, and thank you all.
Thank you so much.
Good afternoon, Your Honors, and may it please the Court. Ronald Coleman on behalf of the state, filling in for Brent Cherry, who authored the brief. He is enjoying his retirement now. This Court should affirm the judgments because the evidence is sufficient to establish the defendant's guilt and because the trial court properly exercised its discretion in admitting the single instance that the defendant is complaining about on appeal. Turning first to the sufficiency challenge, Judge McMullen, I think your questions are directly on point. A rational trier of fact could easily conclude that the defendant placed the victim in reasonable fear of harm when he grabbed her by the back of her head and slammed her head into the top of a counter. The proof was there, it established that, and that alone establishes sufficiency of the evidence.
So help me, because I didn't get the help that I was looking for in the opening argument. Does this have anything to do with, or are we going to be hampered by the fact that the state made what I would consider to be an election?
I don't think so.
Okay,
Again,
help me. You know where I'm going, because
Yes.
they relied on all of these factual instances on the count that was dismissed, right? So I was trying to get some more to flesh that out. Are we barred from considering that?
You're not barred from considering
The
the
facts.
fact, but you're not barred from considering those facts, the head being slammed onto the counter, as proof of sufficiency for the conviction. No.
For this conviction?
For this conviction.
The
not
assault
for the
and fear versus the assault on touching.
on offensive touching,
Yeah.
correct. First of all, the only challenge on appeal is sufficiency, and this court reviews all of the evidence on sufficiency. And here, the state wasn't required to make an election. The fact that it
Okay.
pursued some sort of theory and suggested a way in which the jury could find the defendant guilty on either doesn't preclude this court from examining the totality of the evidence to
So
establish sufficiency.
why is it, my mind immediately went to, so with the state explicitly saying, I want you to look at, I think they said, because I highlighted it, here is the contact that I submit to you is extremely offensive. When he took her by the neck and pulled and pushed her back into the kitchen, pressed her face down on the table, when he gets in her face and he's screaming at her, his spit is hitting her face. That is what they wanted the jury to consider for the assault by touching, offensive touching. So in my mind immediately went to, that was the count that was dismissed.
It certainly is questionable,
So
Your
what do we
Honor.
do with that?
Nothing. This court has repeatedly held, and the Supreme Court has held, that to the extent that there are inconsistent verdicts, that doesn't change the fact of the conviction. And we don't want to speculate as to what the jury did, but the state was simply, in its closing argument, presenting an avenue by which the jury could convict. It's certainly possible that the jury went in the order of counts and found that the head slamming was in fact the assault by causing imminent fear, and then said, well, we don't want to double dip, we don't want to hurt this defendant. We don't know what happened. The question on appeal for this court is, was the evidence sufficient to establish the fact the defendant put the victim in reasonable fear of imminent harm? And that all goes back to the fact that this court can rely solely on the fact that he grabbed her head and slammed it into the counter. Any trier of fact to find that establishes reasonable fear of imminent harm. If this court wants to go beyond that, or if this court has concerns, the state would submit that the statements made also would be sufficient, but unless this court really wants me to dive into that, I think you can rely on the physical act of slamming the victim's head into the countertop as proof of the assault. And I'll turn to the second issue. Here, the trial court properly exercised its discretion in admitting this, and I'll point out the only complained of instance, or the only complained of evidentiary ruling was this admission, allegations of a prior bad act involving a broken tooth. So any other challenges to evidentiary rulings have been waived. But when we're looking at the court allowing the victim to discuss this one incident where she broke her tooth, it was reasonable. First, the court followed the procedures of 404B. It conducted a jury out hearing. It found that the state had established this incident by clear and convincing evidence. It weighed the probative value versus the risk of unfair prejudice and said that that balancing act weighs in favor of admission. And then it looked at, why would this come in? Would this be for propensity purposes? No. This instead is to establish a settled intent to harm, to contextualize both the fact that the defendant, either knowingly or intentionally, and I think that's important, the statute allows for a defendant to commit this assault either intentionally or knowingly. But under either theory of mens rea, this would help to establish the defendant's knowledge or intent of putting the victim in reasonable fear of harm, and it also would go to contextualize the victim's fear of harm to the jury. Is it reasonable that she was in fear of harm when he slammed her head into the countertop, when he's made these threatening allegations, when there was a gun close at hand? And so the court made a proper consideration, and there's no abuse of discretion there. I don't want to belabor the points. If this court has further questions, I'm happy to answer them, but otherwise we respectfully ask that you affirm the judgments. Thank you.
We keep using the word slam here, and you would think that if someone were slammed, that would kind of imply like they're actually injured, there's pain, but from being pushed forcefully into something, and that they might fear that, pain from being slammed into something. But when she uses the word slammed, she later clarifies she's using it as just a synonym for the word pushed. She said, Ms. Lewis, was this just an argument between you and Mr. Cummings that morning? Answer, no, it was much more than that. For you to grab someone and pull them across the house, push their head into a, counter, that's not just an argument. An argument is just some words back and forth. And so I think the only reasonable way to interpret this word slam is that she's sort of using hyperbole there. It wasn't slam in the sense that her face is bruised afterward. It's slammed in the sense that he's pushing her down next to a counter to make her look at something, and he's doing it in an insulting way. She specifically asked how it made her feel. She doesn't describe any pain. She doesn't describe any fear of pain. She just says, she's asked, how did it make you feel when he grabbed you by the back of the head or pressed your face down on top of the child support papers? Answer, he always treated me like I'm nothing, almost like I'm not even a person. Question, did you feel humiliated? Answer, yes. Question, did you feel violated? Answer, yes. Question, did it make you feel small? Answer, yes. Question, did you deserve to be treated that way? Answer, no. And so, again, she had every opportunity, the state had every opportunity to introduce some kind of evidence that this placed her in imminent fear of bodily injury, and they didn't get into that probably because it didn't happen. I mean, assuming she's telling the truth there about how it felt, it didn't feel like she's about to get hurt. And so she didn't fear any reasonable bodily injury from that. And so when the state asks, could a reasonable jury find that slamming someone's head down onto the counter is an assault? That's what the AG just asked a minute ago, and he said, yeah, they could. I mean, if it were really someone just describing being literally slammed into something to where they're actually hurt, I think most people would call that an assault, but that's just, even though she uses that word here, that's pretty clearly not what she's describing. And so, and I don't think the other side really talked much about the Rule 404. I guess I'll just stand on what I've already said on that. We do ask that the judgment be reversed and the either get a new trial or hopefully just dismiss the indictment altogether. Thank you all.
Thank you so much, counsel. The case will be taken under advisement. Madam Clerk, I believe that concludes our calendar for today.
Yes, Your Honor.
All right, so we stand adjourned until the next session of the Court of Criminal Appeals in April.
All right.